Thank you, Your Honor. Your Honor, we're here this morning, case captioned State of Ohio versus Stephen Pekarski, case number 25CR000882. We were last here on January 27th, at which time the defendant entered a written and oral plea of guilty to count 3 kidnapping, a felony of the first degree. At that point in time, then the court referred it for a pre-sentence report and investigation, a victim impact statement, drug and alcohol evaluation, and psychological. Those have been completed, and we are here today for purposes of sentencing. Defendant is present with his counsel, Mr. Myron Watson.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you would like to say at this time on behalf of your client?
Yes, I would.
Go ahead.
The lack of Mr. Pekarski's criminal history. He does show remorse, and he will allocute on that fact. You can see from the letters that have been presented by family members and friends, they truly believe that this person generally has a good soul. I think what's also mitigating here, Judge, is you have Mr. Pekarski, who, for a difficult childhood and early drug use, and I mean, it was kind of shocking to know that his introduction into drugs was at a very tender age. He's tried to work and get over his addiction, but it's come with some hiccups and some missteps, which typically does happen for people who are chemically addicted to heroin and amphetamines. He was, and I think what's mitigating here, Judge, is Mr. Pekarski was in a long-term relationship with the complainant in this case, the victim in this case. There was a very emotionally charged issue about them having a child and his level of participation in that with regard to that child. I think that is factually not in dispute, that the argument and the disagreement and the later actions on his part, wrong, no doubt, but mitigated by the strong emotional situation that he really wanted to be involved with the child. And things spun out of control, and he was not thinking clearly because he was intoxicated, he was under the influence of drugs. That's not an excuse, and we're not using it as an excuse, but we're saying that based upon our contact with the complainant in this case, they feel like he's a good person. And that when our people interviewed the complainant in this case, they indicated that they wanted lenient treatment for him. That at some point when he's gotten his act together, to forge a relationship with his daughter. Mr. Pekarski worked as a carpenter, worked very hard at it, was very good at it. But he had a bad misstep here, Judge, and there's nothing to minimize that. If there's any suggestion in my sentencing memorandum that I didn't believe that this was serious, that's not the case. And he's always acknowledged that he felt that it was serious. His overriding belief that he wanted to be a part of his child's life, and wanted to be a part of a family relationship with the complainant in this case. We're hopeful that the court would take in both the psychological report, which indicates that he was suffering from major depressive disorder, that he's had some mental issues going on that are currently being addressed. And we would hope that the court, with the proper programming and the proper working hard with the tools in which the prison will give him, will help him get over some of his problems and eventually be able to re-enter into society. We're optimistic about that. His mom is here, his sister is here. They're rooting for him. They love him and they care about them because they know what the struggle has been for him. And I know that the state probably said that it's not something that the court should give a great amount of weight to, but we will hope that the court will see its way clear that 9 years is a very long time for someone to be incarcerated. And I believe that Mr. Pekarski wanted to address the court as well.
Certainly, he has a right to address the court. And you do have that right, Mr. Pekarski. You can say anything you want this court to consider before sentencing. Is there anything you'd like to say at this time?
Yes, Your Honor. I'd just like to say that I'm very sorry for what I've done, and I just hope that I can be forgiven and I can be in my child's life. And there's no excuse for what I've done. And I'm very sorry. I've had a lot of time to think about that. And I'm sorry.
Okay.
State is recommending a prison term of 15 years, 6 years for the firearm specifications, and then 9 years on the underlying. Also, as I indicated in chambers, I want to place on the record that I take issue with what the sentencing memorandum says about the victim recanting. That is simply and absolutely 100% not true. She has been consistent from the day of, even in looking at her voluntary statement from June 11th of 2025 when this happened, and up until right before trial. Never once did she change her story. Yes, she felt bad for the defendant. She felt that maybe he had a mental break. She knew that these charges were serious, but never once did she waver. And quite frankly, I thought that maybe at some point in time she might, since she was talking to him on the phone. And when I asked her about it, she said no, she wasn't talking to him. Even though I knew that it was her, and I knew that they were speaking on one of his old phones. So I want to clear that up, because that's, in incorporating the sentencing memorandum, it should be noted that that's not true. When looking at the pre-sentence report, one of the things that I found very lacking was the defendant said that he was just glad that he didn't hurt anybody. And I guess he doesn't realize or can't grasp the extent of damage that he has done. The victim in this matter was so terrified that she ended up getting a protection order. And when you look at what happened that day, it started in the morning when she had been at his mother's house with him. She said she was going to look for an apartment. The defendant was mad about that and was not going to even let her leave the house that morning. When she finally did get a chance to leave, he followed her in his car, was swerving behind her, and she felt that they were going to get into an accident. Now, this is somebody who's saying that he wants to be in his child's life, but he knew full well at that point in time that she was pregnant. That he didn't seem to care about that. Shortly after, Nikki ended up pulling into American Electric, a parking lot there. And the defendant, you can see on the video, you can hear his tires are squealing, comes around, and he slams into the back of her car. She was on the phone with her mother when this happened, and her mother could hear that. He then takes off. She goes to the police department. She says, you know, I don't want to file charges on that, but I want you to know. And the defendant is told to leave her alone. So after that, she's getting ready to go home, and she's on the highway, and the defendant is behind her, and then in front of her trying to brake check her, and she's on the phone with her mom. She's in a panic. Mom says, hey, let's go to the Vrooman Road gas station. We'll go there and maybe we can talk. The defendant follows her there. I don't think the defendant realized that her mother was there at first, and she says, just, you know, leave this alone. Someone's going to get hurt. It gets to be 11 o'clock at night, and the defendant shows up, pulls into the driveway. Victim sees that he is in the driveway. She comes out in her pajama pants, no shoes, no socks, no phone, basically in her pajamas. As she comes out to the truck, the defendant tells her to get into the truck, and she says, no, I'm not going to get in. He then pulls a gun and says, get into the truck. She doesn't want to get in, and so he grabs her by the back of her hair and he throws her in the truck. Again, she's pregnant, he knows this. They're driving around, and while they're driving around, he's yelling and screaming at her, saying, this will all be over soon, I'm going to kill you, I'm going to kill myself, and she's terrified. So this has gone on from morning until late at night. He even takes her at one point in time down a road, Wood Road, and that's actually where her sister had died as a result of a car accident. Drives her through that area, still saying that he's going to kill her. And whether you believe what he says to the police, that at some point in time they're arguing and he stops the car, shoots the gun off, and it goes through the roof of the car, or what she says is that he's so angry that he's slamming his hands on the steering wheel that he has the gun in his hand and it goes off. Not only that, but then he's slamming the gun on her leg to the point where she gets bruises. He tells her when they go to his house, they go back to his house. This is all the way from out near Madison Avenue, takes her all the way to Geneva, tells her don't do anything funny when she goes inside the house, gets her back into the car, and luckily he then takes her over to the gas station. And when he goes over to the gas station, he has to go inside. And you can see on the video of her, as soon as he goes inside and that door is closed to that gas station, she hightails it out of that vehicle and she runs over, and luckily she's across from the Geneva Police Department. She is trying to open those doors, looking. And when I talked to her about it, I said, why'd you keep looking back? She said the thing that scared her the most is that she was going to get shot in the back. She then goes around to the back of the police department. She's banging on the doors there, and luckily one of the officers lets her in. Normally, nobody would come in that way. All the doors had been locked. And then you see him on the videos driving past the police department, driving back and forth, looking for her, still even after that. Now, one of the officers from Geneva saw the truck, and so when she goes inside and describes the truck, one of the officers realizes he has just seen that. He goes and he ends up pulling the defendant over while he's pulling into where he lives. He ends up he does have the gun in the car. I'm not sure at what point in time he unloaded the magazine of the firearm, but one of the reasons that we know the magazine was still in there for a period of time is not only did that one bullet go through the roof of the vehicle, but there was still one in the chamber. And although the magazine had been taken out and there were rounds all over the car, there was still one in the chamber, and unless he actually put that in himself, it fed from the magazine. The other thing that was interesting, and talking to the Geneva Police Department, they couldn't figure out why when they went up to the truck the first time, they could hear their voices and they could hear dispatch. The defendant had a second phone in his car, and he had this app called Broadcastify on his phone, listening to what the police were doing. So when you look at all those factors and how long this incident occurred, and then the defendant saying no one was hurt, he clearly doesn't understand that emotional and physical are both injuries. So when you look at the facts and circumstances of this case, having 15 years and asking for 9 on the underlying, I don't think that's out of the realm of what's appropriate at all. The minimum would completely demean the seriousness of this offense. This is one of those situations where when we talk about kidnapping, sometimes it's the technical violation, the kidnapping. This is why the statute was written. And we would ask then that you give the 6 years on the underlying offense, and then 9 years, on 6 years on the firearm specifications, and then 9 years on the underlying offenses, however the court deems that that would be appropriate. There is no merger. These are separate and distinct offenses.
Victim did suffer serious psychological harm, that the relationship with the victim facilitated the offense, and other relevant factors indicating the conduct is more serious is the fact that a firearm was used in this offense and actually was discharged, and also the fact that the victim was pregnant in this case. Those are all factors indicating the conduct is more serious, and he knew she was pregnant. Nothing makes it less serious. Therefore, it will be the sentence of this court that on count 3, the defendant serve an indefinite prison term of a minimum of 4 years, maximum of 6 years. On count 5, he serve a prison term of 4 years. The prison terms will run concurrent with each other. However, both counts carry 3-year mandatory firearm specifications, and those will be imposed for each count to be served prior to and consecutive to each other, and consecutive to the indefinite prison term of 4 to 6 years, for an aggregate indefinite prison term of a minimum of 10 years, maximum of 12 years.